Price.
Please the Court. In this appeal, I appear for the appellants, Independent Print Ltd and Evening Standard Ltd, with Jonathan Price and Adrian Page, Queen's Counsel, and Godwin Basuto appear for the respondent, Bruno Lachaux. The Court has the benefit of written submissions from the MLA.
Before you begin, can you explain why there are two statements of facts and issues in this case?
Well, an attempt was made to try to reach agreement. That did not prove possible, and guidance was sought from the registry, who suggested that two statements should be filed.
Irrespective of the guidance that you may have received from the registry, Rule 22 of the Rules of the Supreme Court, you will know, requires, among other things, that the appellant prepare a statement of facts and issues, and Rule 22.2 requires the appellant to submit that statement to and agree it with every respondent before it's filed. Practice Direction 513 provides that the statement of facts and issues must be a single document. The statement must set out the relevant facts, and if the parties cannot agree as to any matter, the statement should make clear which items are disputed, and it should be signed by counsel for all the parties. The statement of facts the Practice Direction makes clear is a neutral document and is not to be used to argue a party's case. And most significantly, it stipulates that it's the professional duty of the party's legal representatives to cooperate to produce the statement. The party's legal representatives in this case have failed to discharge that duty, and that failure is to be deprecated. The SFI is not an occasion for self-indulgent assertion by the parties or their legal representatives. In appeals that generate far greater controversy than does the present, SFIs have been agreed between the parties to the appeal. There is no reason, in my estimation, that a single SFI should not have been filed in this case, and it's to be hoped that the example of today's proceedings will not be repeated. Yes, thank you, Mr. Price. You may proceed.
Apologise.
Yes, sorry.
The two main issues that are raised by this appeal are, firstly, the construction of Section 1 of the Defamation Act 2013. What is meant by has caused or is likely to cause serious harm to the claimant's reputation. And, assuming that the appellants succeed on construction, secondly, the circumstances in which the court should draw the inference of serious harm to reputation in the absence of any evidence of it, in particular the extent that it can be inferred from the seriousness of the imputations conveyed by the statement by operation of the common law rules for determining meaning. The respondent has directed most of his case to the first issue. I have sought to give equal prominence to both. That's not just because to succeed on this appeal, my clients have to overturn the judge's finding that serious harm could be inferred, but in practice, I submit, unless the reliance on inference to satisfy the Section 1 hurdle is properly circumscribed, the serious requirement in Section 1 will be diluted and the end result no different to how it was prior to Section 1 coming into force. On this issue, in summary, the appellant's case is that reliance on inference to prove the existence of serious harm in the absence of a claimant adducing any evidence of harm should only be permitted in an obvious case, that is, where the circumstances are such that the publication of the statement is so obviously likely to cause serious harm to reputation that it would be unnecessary and disproportionate to adduce such evidence. The meaning conveyed by the statement is only one part of the relevant circumstances. The present case is not an obvious case for a number of reasons which were advanced by the appellants before the judge and the Court of Appeal but not reflected in their judgments. This appeal also raises three discrete issues of law which relate to circumstances that commonly arise in the coverage of news stories in the modern era and are relevant to whether an inference of serious harm should be drawn. The first of these is whether the repetition rule applies to Section 1 determination. In other words, whether the defendant can say it was reporting someone else's allegations, and that is a factor in whether serious harm should be inferred. Secondly, whether the rule in Dingle applies, in other words, whether previous publications to the same effect can be taken into account when determining the harm caused by the subsequent publication. And thirdly, whether readers who may get to know the claimant after a Section 1 determination are in general relevant to has caused serious harm to reputation or is likely to cause serious harm to reputation. I was proposing to take these 5 issues in the order that I have referred to them, which reflects the order in the written case, but I'm happy to take any other course that would be of assistance to the court. I'm not going to repeat all the introductory points in my case about how the court must apply Section 1 faithfully and dispassionately. Clearly doing so will result in less defamation cases and perhaps equally importantly, less scope for the chilling effect arising from the threat of a claim. It's plainly what Parliament intended. In the light of the respondent's case, it's worth reiterating before I start the point made in the introductory part of the case, which is that the court needs to adopt a can-do attitude to Section 1. It's a key provision in implementing Parliament's wish to rebalance defamation law in favour of freedom of expression, not just for the benefit of the media, but for the benefit of anybody who publishes material which may be defamatory. We've seen in the era of the internet increasing number of cases involving individuals who maybe go on Facebook, send out an email. The same law has got to apply. The same construction of Section 1 has to apply. In my submission, Parliament's intention is crystal clear from the language it has used. That intention should not be frustrated by a rearguard action by those opposed to the liberalising effect of Section 1, relying on submissions that I would respectfully suggest amount to a combination of the tail wagging the dog, inter rorum, and no can do. If I can start with the construction of Section 1, which can be found in the Volume 1, Part 1 of the Authorities Bundle at Tab 1, which is on page 7 and page 509 of the electronic bundle.
Sorry, which page again, please?
509.
509 of the electronic bundle.
Thank you.
On 1, a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. It's worth looking at 1.2 because that impacts on the construction of 1.1. For the purpose of this section, harm to reputation of a body that trades for profit is not serious harm unless it, that's a serious harm, has caused or is likely to cause the body serious financial loss. The definition of publication, and statement can be found in section 15, which is on page 17 of the bundle 521, 519 of the electronic. That definition in section 15 is also to be found, I think, almost identically, or perhaps identically, in the 1996 Defamation Act. Provides that publish and publication in relation to a statement have the meaning that they have for the purposes of the law of defamation generally. It's necessary for that definition to be there because the ordinary meaning of publication to a layperson would be to communicate to the public, where, of course, the law of defamation applies to any communication, and a conversation between two people is regarded as a publication. It simply means the act of communicating the words from the publisher, the person who is speaking or writing them, to the publishee, the person who's receiving them. Statement means words, pictures, visual image, gestures, or any other method of signifying meaning. That must mean, in the present case, the article complained of. And I don't think there's been any issue thus far, or indeed there's any issue in the appeal, that if one then goes back to section 1.1, what the respondent has to show is that each article complained of separately, the publication of each article has caused serious harm or is likely to cause serious harm to his reputation. So you can't, as it were, look at the composite media publication of the imputation conveyed by the statement. You have to look at each article in isolation and apply the serious harm test to that article, which is what the judge did. It may be noted that the truth defence, section 2, which replaces the common law defence of justification, does not refer to the publication of the statement. It refers to the imputation conveyed by the statement. I think it's uncontroversial that imputation really means defamatory meaning. So section 2 is just looking at the meaning conveyed in abstract, and then the concrete is whether the meaning is true. Well, obviously evidence relating to that, but it's just looking at the meaning in abstract. And on the respondent's construction, the Court of Appeal's construction, that's all that matters in determining whether a statement is defamatory. It's the imputation that is conveyed by it. But that's not what Parliament said in section 1. Parliament said it's the publication of the statement that has to cause the serious harm. And most obviously, in terms of how this section 1.1 is to be construed, is that has caused is referring to the past, and it's being contrasted with is likely that's being it's referring to the future. I mean, any ordinary person reading that, or indeed any lawyer reading that, would see that as the obvious meaning and two ways in which the section can be satisfied. As it happens, the words is likely to or would be likely to are commonly used in statutes to refer to a future event or consequence. And that was noted by Mr. Justice Bean and Mr. Justice Warby, whose construction of section 1 I seek to defend and was rejected by the Court of Appeal. Perhaps we should just have a look at Preem Holdings, which is an example of the use of is likely to refer to a future occurrence. That can be found in volume 1, part 1, so it's the same bundle, and it's tab 16. The electronic page is 796. That's actually the relevant passage that I'm going to go to, which is on paragraph 21 of the...
796.
Sorry, 791 is the passage, forgive me, my lord.
I've got AB 281.
Yes, that's the start of it, but the particular part I'm going to take the court to
600 pages long.
Is on page 289. It's 791 of the electronic bundle. It's paragraph 21.
Yes?
The future occurrence in this case is what would happen at trial. It's a case involving interim injunctions, and it's a statutory provision in section 12 of the Human Rights Act, which provides that relief shall not be granted at an interim stage unless it's likely that the claimant would succeed at trial. So that requires the court at the interim stage to make a prediction as to what's going to happen at trial. It's clearly looking forward. And in paragraph 21, one has examples of is likely.
That's very interesting. I was going to refer you to section 31 of the 1989 Act, but you've already noticed it because Lord Nichols is here referring to it. So you will have seen that in fairly similar circumstances, no care order being able to be made unless the child has suffered significant harm or is likely to suffer significant harm. Yes. The word likely has been construed there as meaning not probable, but a real possibility that cannot be ignored.
Yes.
And so it's all contextual. And so you will have to help us as to why the context here drives a conclusion different from that to which we family lawyers place upon Section 31.
At the moment, I'm just focusing on the question of what the meaning of has caused and is likely to
Well, I
cause.
know you are.
I obviously have to deal with, if I'm right that is likely to cause is future harm, then one would have to consider how it would be applied in generally, and in a case like this. But, I mean, the judge did find that if he held that if he hadn't have found that serious harm had been caused, he would not have held that it was likely to be caused in the future. That's not a finding that's against me on this case. But for the moment, why I rely on this passage is because of the juxtaposition in tense. Certainly, is suffering, well, that's present tense, but it also clearly covers things that may have happened in the past, or is likely to suffer. It clearly refers to the future. There can be no doubt about that. And similarly, there can be no doubt about it in the present case. And then there's reference to Section 8.1 of the Insolvency Act, and would be likely to achieve. Question, if I'm right that the section clearly contemplates something that's happened in the past and something which may happen in the future, the question arises as when is the dividing line between past and possible future harm?
Why do we have to look for a dividing line, Mr. Price?
Well, because the statute contemplates two ways in which the serious harm requirement can be satisfied. Something that's happened.
Well, you've said past, future. Why do we need to go further? Look for some dividing line, with whatever degree of difficulty.
Yeah, well, I mean, in my submission, it's fairly straightforward. At the date of the determination, the court looks and says, has serious harm been caused? And if it hasn't, then it asks whether it's likely to be caused in the future. So it seems to me fairly straightforward. It was just that Mr. Justice Bean, in the Cook case, was of the view that the dividing line should be the date of the issue of the claim. I was in that case and I submitted that it should be the date of...
Yes, well, the courts have wrestled with this dividing line, and we want your help on why we need to wrestle with that too.
If I'm right, that has caused involves looking back to the past and is likely to involve looking to the future, then one would have to ask, when is it that you...
Yeah,
it's a date of trial.
It's the location of the dividing line.
Yes, I'm sorry. Yes, it's a date of trial. Because this is a simple question. The judge asks, looking at this, has serious harm been caused? If it hasn't, is it likely to be caused in the future? It seems to me extremely straightforward. And that's the way that the judge, Mr. Justice Warby, approached this. And in my submission, he was obviously correct to do so. I simply dealt with this because Mr. Justice Bean suggested the date of the claim form, which in my submission would make things more complicated. But clearly, the question is being asked at the court as at the date of the determination.
Well, there's a certain logic, I suppose, to your submission that if you're asking yourself the question, has serious harm been caused, that's obviously something that requires you to look back from the time that you're making the determination. And if you're asking yourself the question, is it likely that serious harm will be caused, then you're forecasting from that time.
Yes, that's my submission. So what is meant by reputation? I mean, it's actually not been defined, I don't think, in the cases. Never really had to have a focus on harm to reputation. It's not been an essential cause of the action. It's been presumed. In my submission, clearly, the ordinary meaning of reputation is the beliefs or opinions that are generally held about someone or something. Obviously, harm to reputation must involve a lowering of opinion. So then we move on to my submission, the most significant word in this section, which is serious. In the context of Parliament starting off with substantial and then moving to serious. Serious harm has a well-established meaning in other contexts involving a high level of adverse consequence. I've referred to the provisions of the Criminal Justice Act and also an EC Council directive in relation to refugees. It's not necessary to go to them. I'm not suggesting that there's a direct analogy. I simply say that the word serious is a word that necessarily imports a consideration of actual or likely consequences. And if any harm to reputation has not had and is not likely to have any adverse consequences, it is difficult to see how it can be categorized as serious. May I just make clear that, as I've gone through the words comprising the section is not a definition of what is defamatory, as the judge correctly recognised. It sets another hurdle for a claimant to surmount. The existing hurdles, common law hurdles, remain in place, as the judge correctly recognised. It's just a further hurdle that has been imposed on a claimant. One has to look at the section in the context of the common law, which clearly one has to. Starting point in terms of the common law's assessment, in fact, end point of the common law's assessment of whether a statement is defamatory, is to ask, firstly, what imputations are conveyed by the statement. And that process is determined by established principles of construction. Second question is, does any imputation tend to make right-thinking members of society generally think the worse of the claimant? Tend to, emphasize it. It's directed solely to the moral quality of the imputation that is conveyed by the statement. If that imputation has the requisite moral gravity, the statement is actionable as a defamation, even if its publication did not cause any harm to the claimant's reputation. I've given the well-known example of Lord Justice Goddard in Hoff. If words are used which impute discreditable conduct to my friend, he's been defamed to me, although I do not believe the imputation and may even know that it is untrue. Conversely, if the imputation does not have such a tendency, the fact that its publication has caused serious harm to the claimant's reputation will not make it defamatory. This most commonly applies where a particular section of society disapproves of the conduct. But that doesn't represent the consensus. Well-known cases involve the suggestion that someone is a police informer. It would be very damaging, but right-thinking members of society do not think the worse of people who report crime to the police. I've called this requirement the consensus requirement. So not only does the claimant not have to prove any harm whatsoever, similarly, it's not open to the claimant to prove harm if the tendency test is not satisfied. And the tendency test just involves looking at the words comprising the statement in isolation of anything else. Now, that rule has come in for a certain amount of criticism. I cited from Lady Hale when she referred to Professor Weir describing it as possibly odd. There was a renewed focus on it arising from the Human Rights Act 1998, which incorporated Article 10 of the European Convention of Human Rights into English law. And the jurisprudence relating to Article 10 recognises that the fact of being sued for defamation or the threat of such a claim amounts to an interference with freedom of expression within the meaning of Article 10, so it has to be justified. Question therefore arose as to whether this very limited common law requirement to establish a claim was sufficient to justify the interference of being sued. It's not enough just to turn around and say, oh, well, if it's true, you're okay, if you can raise a defensive opinion or it's true, whatever it may be. The availability of potentially costly defences was felt to be insufficient protection, and therefore it was necessary to set a higher entry barrier at the pre-defence stage. That analysis can be seen in the case of Thornton, which I'll come on to. But what it makes clear is you have to erect this barrier at the start. If you make the defendant have to run his case to trial, then he's going to have to incur a large amount of costs, and then you have the chilling effect of people being able to commence claims, put the defendant to expense and possible risk of outcome, because no one can be totally certain of the outcome. And therefore, for this to be avoided, there needs to be a meaningful hurdle at an early stage. And two hurdles were erected, and they are different hurdles. And they're both reflected and subsumed into Section 1.1, which I'll come on to. They're conceptually very different, and it's important to keep this in mind at all times. The first is the Jamil jurisdiction. The Court of Appeal decision in 2005, Jamil and Dow Jones. This enabled a claim to be struck out as an abuse of process where it disclosed no real and substantial tort. The significance is that this was the court looking back at the date of the determination to assess the reality of the reputational harm that had been caused. It wasn't just about the meaning of the words. The seriousness of the imputation clearly was a factor. But in Jamil, the imputation was funding terrorism. That was a very small-scale publication. However, the Jamil jurisdiction, while it provided some benefit to defendants, was not entirely user-friendly for two main reasons. Firstly, the absence of harm didn't necessarily lead to a finding of abuse. And if there was any conflict of primary fact, because this was a strikeout application and abuse of process, it was assumed that the claimant would succeed on it at trial. So you could quite easily find yourself as a defendant at trial. But the important point about Jamil is that it's multifactorial, as the judge described it. It involves looking at all the circumstances, looking back to assess the reality of the extent of any reputational harm. The next development was in 2010 in the case of Thornton and Telegraph Media Group. In that case, Mr. Justice Tugendhat held that any definition of defamatory had to include a threshold of seriousness. There were a number of, I'm going to come on to the case, but just by way of introduction, there was a number of definitions that were cited by the judge, and definition 9, which was the one he amended to include this threshold of seriousness, was amended with the word substantially. So definition 9 became substantially affects in an adverse manner the attitude of other people towards him or has a tendency to do so. It's important to recognise that Thornton was a meaning case and a meaning case alone. If we can now go to Thornton, which is in court, it's the Authorities Bundle, Volume 1, Part 2 at tab 32. It's at page 681.
Do keep your voice up, Mr. Price, because I know we can hear.
Yes.
It's important that the people at the back of the courtroom also
Okay.
You say 681.
So in the
Electronic.
sorry, forgive me. It's been a slight problem. It's the electronic bundle. It's at 1165. It starts. It's tab 32. Yep. If I can ask the court to go to paragraph 7, please. There one sees the words complained of.
Could you give us the electronic bundle page, please?
Can you give me the authorities bundle again, please?
I'm sorry, yes. The authorities bundle is volume 1, part 2, tab 32, page 666. and the electronic bundle is 116. Sorry,
So volume 1, part 2, tab,
32.
32,
thank you.
and it's 116.
Paragraph 7 is at 1168.
Yes, 168. I'm most
My
grateful.
bundles are numbered in a different way.
Oh, I'm terribly sorry.
Paragraph 7
Yes, is
is on,
AB 666?
yes,
Yes.
I only have AB numbers.
Yes, I'm sorry. Sets out the words complained of. It's an article in the Daily Telegraph. It's a review by Lynn Barber about a book concerning the art world. The allegation is copy approval. Lynn Barber says that Dr. Thornton offers her interviewees copy approval. If I can just ask you to read the extract from the article.
Yes?
Feature of the case was that the author of the article, Lynn Barber, and the claimant both disapproved of copy approval. The only issue in the case was whether that imputation was defamatory. Although the article was in the Daily Telegraph, it wouldn't have made any difference if it was in an email to one person. The challenge was made by the defendant that it wasn't capable of being defamatory. One can see that in paragraph 15 on page 668, 1170, electronic bundle. And then on the following page, paragraph 19, one can see the familiar common law test for determining meaning set out by the judge, citing an earlier case of Janes and News Magazine. So that's how the article has to be construed. And then the submissions that were made by the defendant are at paragraph 20. There had to be a threshold of seriousness. It's based on Article 10.
As we go through this, what are we looking for exactly,
Okay.
relevant to
Yes.
this appeal?
Yes. The reason I'm going to is because the Court of Appeal's decision was that the effect of Section 1 was simply to codify this case of Thornton and raise the bar to seriousness.
Your submission, as I understand it, is that this is the authority for the tendency inherent in the words test.
Yes.
And that is the test that you say has been displaced by Section 1.1.
Yes, I do. And because of the way the Court of Appeal went through Thornton and relied on it, as it were, as evidence of Parliament's intention in using the words that it did in Section 1, I thought it was necessary to go through the case. But the short point is really, this is just a tendency case. And if Parliament is assumed to know the law, at the time it incorporates Section 1, which clearly it does, all Thornton is doing is making the requirement from a tendency to cause harm to reputation to a tendency to cause harm to reputation of a certain level of seriousness. It's not doing very much, and clearly Section 1 is doing more.
It is clearly doing, I mean, the argument is that Section 1.1 filters out.
Well, I suppose that depends on what I'm...
doesn't just raise the bar of seriousness, it requires a factual investigation into the actual impact.
Yes. Yes. Well, inherent consequences. I mean, just looking at in isolation, the imputation conveyed by the statement is clearly not enough. It's one of the factors, but not the only one.
You're saying it's not just that it's got to be a bad libel.
Yes. Yes, which may be inferred in an appropriate case, but clearly Parliament's intention in using those words is to take the inquiry beyond the inherent tendency of the words comprising the statement. It must be clear. And if we need to go to the parliamentary material, it's overt from that. I mean, my primary submission is that the words are sufficiently clear. The context of the common law as it was at the time the Act came into force. No one doesn't have to go to the parliamentary debate, but if we go to the parliamentary debate, there is an explicit statement by Jonathan Giannogli saying that they didn't want a tendency test because it was too abstract.
Well, we've seen the Media Lawyers Association submission, which sets that out in extensive, which we will take into account the Bene essay, but whether it's admissible is another question.
Yes, I mean, I'm saying it's not necessary to go there because it clearly has caused a statement. The harm to reputation that a publication of a statement has caused is clearly going wider than the imputation conveyed by the statement. It's notable, as I said, when I went through the opening sections of the statute, that Section 2 refers to the imputation conveyed by the statement, which is the Thornton imputation, whereas Section 1 refers to the publication of the statement. Perhaps I won't need to go any further with Thornton then, but I said that the limitation of Jamil was that the absence of harm didn't lead to finding of abuse. There were problems with it for a defendant. The clear limitation of Thornton is that it just relates to the meaning of the word. So the example I gave earlier, Lord Justice Goddard's example, words are used which impute discreditable conduct to my friend are defamatory even if he doesn't believe it. That still applies. And it still applies on the Court of Appeal's construction, obviously, because that's just says that the Section 1 is Thornton plus, and that's the submission that is being put on behalf of the respondent, albeit not relying on is likely to cause, which is how the Court of Appeal looked at it, but on the words has caused. So I have a section in my case in relation to the parliamentary scrutiny, which I probably ought to go through, even though my submission, the words are sufficiently clear, but the judge looked at it and the Court of Appeal looked at it. So unless I'm told not to, I propose at least briefly to go through it.
Well, I think a fairly brief summary is all that is required.
Very well.
Yeah.
This was an act that went through a considerable amount of scrutiny. This is not Parliament acting with ignorance of the position. It's an issue of public policy. Clearly, different people can have different views about how much harm, if any, a claimant should have to prove. Courts can only decide the case that comes before it. Naturally, on occasion, swayed by wanting to do the right thing by the claimant, the Parliament considered all the factors, and factors that just don't appear in a court case, which is what is the chilling effect on others who may wish to publish material resulting from this decision. I mean, there was very widespread consultation on this bill. And it started life as a requirement to cause substantial harm. That hurdle was raised after the Joint Committee reported on it. The reason why it was raised was because if one didn't have a higher threshold, there was this risk that trivial claims could still go through. So Parliament quite clearly wanted to urge on the side of exclusion of claims. The claimant would have to do some work, more work than before, to justify being able to bring a claim. I've set out 5 factors which are evident from the parliamentary scrutiny, which are inconsistent with the Court of Appeal's construction and equally inconsistent with the construction urged upon this court by the respondent, which is simply a different iteration of the tendency test. The first, all the circumstances prevailing at the date of determination are relevant to the assessment of serious harm, including steps following publication to mitigate any harm. Give the references. For that, I've given some references for that, and they're probably sufficient. I'm going to go through this quickly. Is likely to cause, this next point, is likely to cause is not to be equated with a tendency to cause. We've got the Minister's statement. We've got the explanatory notes, both in relation to the bill itself and also the explanatory notes in relation to the draft bill. That is likely is to refer to future harm, not future publication, future harm. Corporations must prove serious financial loss has in fact been caused. This was a contentious issue, a large amount of impassioned debate. Section 1.2 in my submission unambiguously requires proof of financial loss having been caused or that it's likely in the future. If is likely to is equivalent to a tendency, which is Court of Appeal's reading of is likely to, then it must equally apply in relation to Section 1, in which case corporations can simply rely on the gravity of the imputation in abstract without having to prove any actual loss. That was the preferred option of those who opposed Section 1.2, said it would be a bad idea, companies wouldn't be able to protect their reputations. They lost that argument in Parliament, but the position now, as is evident from 2 cases, one of which I've cited, is that trading corporations now, on the basis of the Court of Appeal's judgment in this case, only have to show that the imputation conveyed by the statement has a tendency to cause serious financial loss, whatever that means in practice. The next point is that Section 1 was building on Thornton and Jamil. Plenty of references to both those cases in the scrutiny, and also it's explicit in the explanatory notes. And finally, and in my respectful submission, importantly, Parliament recognised that Section 1 could involve a front-loading of cost, including evidence having to be given, but judged that the overall cost savings in terms of reduced defamation and also the absence of the chilling effect of threatened claims was worth it. This is a cost-benefit judgment that Parliament was entitled to make. It shouldn't be frustrated by the courts, in my respectful submission, by saying that some of these Section 1 determinations have taken place at disproportionate cost. They may well have done, but the question should be asked, why cross-examine a claimant? Is it really necessary to cross-examine a claimant when the issue is not about injury to feelings? Is there a relevant conflict of primary fact that needs to be resolved to reach a proportionate conclusion on Section 1? I mean, the first Section 1 case was Cook, which I've referred to. That was over in a day. No cross-examination of the claimant. We had to have a meaning determination first. This present case took longer because of an unnecessary cross-examination of the claimant, but as the judge recognised, these hearings are capable of being conducted much more quickly on a proportionate basis. But the fact that there may be some further cost is not a reason for frustrating Parliament's intention. And for what it's worth, although this isn't an issue which is directly raised by the grounds of appeal, in my submission it's quite clear that this Section 1 determination should take place at the outset of the case. Because the aim is to weed out claims that don't involve serious harm. The next section...
That weeding out may also be achieved, may it not, by a perception that if that problem is going to rise at trial, and and the claimant can see that he's not going to have any ammunition at trial on that issue, he won't start his claim.
I think there are 2 points can be made in relation to that, if I may. The first is, if the test is simply a tendency, and I can assure you that the legal profession post the Court of Appeal judgment know that it's a limited tendency requirement. The fact that the section is headed serious harm is not acting as a deterrent to anybody. I mean, letters are now arriving saying this article has a meaning which is serious, therefore serious harm will be inferred. The second point is that the context in which this section came into force was the perception that English defamation law was being used by rich people to chill speech. And the points that my Lord is making may not deter people who want to chill speech, who can throw some money at something and make things hard for a defendant. No doubt, the deterrent effect of having a meaningful Section 1 hurdle will impact on some claimants who would otherwise have had a go. But the reasoning of Parliament, and it's evident from the earlier cases of Thornton and Jamil, is that one needs to address this at the earliest possible stage to minimise the deleterious potential effects on freedom of expression. But my main aim, forensically, in this case, is to contend for the construction of Section 1 that the judge gave to it, and then to address how it may be proved. It's not at the forefront of my submissions as to when it would need to be proved. But it would seem to me that the logic of it would be as soon as possible. Because then you would have a lot of costs involved potentially litigating a truth defence, which was irrelevant because there was no serious harm.
Well, we all understand your complaint about your complaint about the judge's interpretation of likely to cause. What other aspects of his interpretation of Section 1.1 are you complaining about?
The judge?
Yes. No, the Court of Appeal.
Yes. Well, the interpretation of Court of Appeal's interpretation of Section 1 is that is likely to.
I know.
Is a
Put that
tendency.
aside.
Well, if that's the case, then has caused becomes OTOs. Has caused wasn't even a
Put is likely to cause,
yes.
and his Lord Justice Davies' interpretation of that on one side.
Yes.
There is a complaint about that.
Yes.
We understand that.
Yes.
We'll deal with it. What else do you complain about in terms of Lord Justice Davies' analysis of the section?
Well, I'll take it in stages, if I may. He says that is likely to is equivalent to a tendency, and then he says, ordinarily, the Section 1 test will be satisfied on the basis of the meaning determined at the meaning hearing. He contemplates the possibility of a further hearing after the meaning hearing. This is at paragraph 82, where he states his conclusions. But there can't, if Section 1 is, as the Court of Appeal say it is, simply an enhanced version of Thornton, there can be no issue after the meaning determination at all. Because it's a binary exercise. Either the meaning is sufficiently serious, in which case no evidence is required, or it's not, in which case no evidence is admissible.
Very well, thank you.
Lord Justice Davis also deals with the approach of inferring serious harm, but that's not really an issue in relation to the construction of the section.
Quite.
I mean, once it's said that Section 1 is simply an enhanced version of Thornton, then if that's wrong, that's really the end of the inquiry is in terms of how Lord Justice Davis went about it. He placed everything on Thornton. The obvious benefit of placing everything on Thornton is that one doesn't have to have an inquiry as to the reality of reputational harm. But Parliament considered that. In support of his construction, Lord Justice Davis referred to certain problems that would or could arise if my client's construction and the judge's construction was upheld. So I do submit that he was wrong in how he approached that, and that there aren't any problems on proper analysis with this construction. So I was going to come on to dealing with the no-can-do element of the case that's against me, which featured in the Court of Appeal. We can't do this because there's problems with limitation. We can't do this because it impacts on other statutory provisions. But again, I was going to deal with that separately. I can go into. I'm just trying to go through to explain why the Court of Appeal's construction is incompatible with what Parliament wanted, and I think I've probably done that. So perhaps I should move on to the problems that are said to arise from the construction which my clients are contending. It says that there's a problem with limitation. In my submission, that is more theoretical than practical, and in any event can't be a means of detracting from Parliament's clear intention in relation to Section 1, and this Court has to focus on Parliament's intention. So if there's any problems with limitation, one has to ask whether that was what did Parliament take this into account, and is that a way of construing Section 1.1 in a different fashion? What is the position on limitation? In my submission, it is absolutely crystal clear that Section 1 means that libel is no longer actionable per se. That harm is an element of the cause of action. Lord Justice Davis referred to this being swept away silently. In my submission, it's screaming loud and clear from the words of the section. So given that it's a requirement to prove harm, then the time only runs from the date on which either the harm is caused or it's likely to be caused. So whichever way this works, it will have the effect of pushing back time. It will give a claimant more time.
But the Act continues to assume that time runs from the date of publication, does it not?
Well, there's Section 8.
Yes. Rather than from when some damage occurs.
Well, it's a question whether it assumes it. I mean, the Section 8 is looking back to the second publication, goes back to the date of the first publication.
But yes,
Yeah.
but the underlying thinking throughout Section 8 is that the cause of action is complete on publication, because that's when time starts to run against you.
Possibly.
It would be odd, wouldn't it, if time was running against you when you didn't have a cause of action?
Yes, I mean, it assumes that the first time will run from the first publication,
Yeah.
the date of publication, which in my submission it almost always will. I mean, it's important to draw a distinction between whether serious harm has been caused, and if so, when it has been caused. My submission on the second point, on drawing inferences, is that if there's no evidence of any adverse consequence, one shouldn't draw the inference that serious harm has been caused, unless it's obvious. But if serious harm has been caused, the likelihood is it will be caused on the date when the words were read and the claimant thinks the worse, the publisher thinks the worse of the claimant. Whether that is serious.
But I mean, there are cases where the allegedly defamatory statement is made, let's say, to a regulator or someone who files it away, and I think has famously been said, it then percolates out into the public domain years later.
Yes.
But on your analysis, as I understand it, if it didn't percolate out into the public domain so as to cause serious harm rather than a raised eyebrow in the regulator's office,
Yes.
that might be well over 1 year after the publication, and yet the claimant would, subject to getting the time limit disapplied, be
Yes.
statute barred.
Well, if one breaks down the analysis there, so the publication is made to the regulator. It's not. Is it? I mean, the obvious issue would be: is it foreseeable that it would be made public? I'm thinking about the potential liability of the person who made the complaint to the regulator, because the person who made the complaint to the regulator would only be liable if it's foreseeable that it was going to be published subsequently. And if it was foreseeable that it was going to be published subsequently, then the person who made the complaint would be liable for the publication to the public,
Yes, but
on ordinary grounds.
I'm simply using that as an example in the case where the accrual of serious harm
Yes.
may take place a long time after the publication, to meet your point that in many cases it'll be simultaneous.
Yes, but it's the
Test
second
your
publication. It's publication to the public that gives rise to the cause of action. That would be the cause of action that you would be suing on, it having been made to the public. And the limitations, you'd have a year from it having been made to the public. When it went to the regulator, it wouldn't be relevant, because you wouldn't be suing on that. You'd be suing on the subsequent publication. And if that was a foreseeable consequence of the publication to the regulator, then the person who made the complaint to the regulator could be potentially liable. And in any event, the person who makes the complaint to the regulator public would be liable. So the publication of the statement, which would form the cause of action, would be the publication to the public at the later date. And time would run from that date.
So even if it wasn't foreseeable at the time that the statement was made to the regulator, that it would be released to the public, your point is that that doesn't matter, because when in fact it is released to the public, unforeseeably, that's the point at which the cause of action arises.
And all those people who are responsible for that publication to the public would be potentially liable in defamation.
Right.
If we're looking at Section 8, the limitation point, as an indication of Parliament's intention in relation to Section 1, it's also relevant to bear in mind that it's clear from Section 1.2 that trading corporations have to prove financial loss. Therefore, the cause of action can only arise when the financial loss has been suffered, which may well be after the date of publication. I think it's now conceded by the respondent that trading corporations do have to prove financial loss, although it can be done by inference. So inevitably, we have the potential situation in the case of a trading corporation where the first publication has a later expiry of limitation period than the second publication. Well, there's no scope for injustice here, because there's all it will have the effect of doing is giving a claimant more time. Why should a claimant even take a risk and sue outside the 1 year period? There's no reason for a claimant to do that. But even if he were to do that, it would give him more time if the limitation period is pushed back. And there's a general equitable discretion in any event, so that the court can do justice on its case. I mean, allowing Section 8 to control the ordinary meaning of Section 1 would be clearly the tail wagging the dog. It's not. Section 1 works, notwithstanding Section 8. And at worst, there's simply been an oversight. But in practice, I do submit, in a media article, if it's caused serious harm, it's going to be caused on the day of publication. Because I accept, in principle, that the harm is the reading of the article. My point in relation to seriousness is that unless that harm is likely to or has caused some sort of adverse consequence, then you can't safely say that it's serious. But that would be a situation where serious harm has not been caused. It's also said that there's a possible uncertainty as to when another way, if one has to grapple with the limitation point, another way of looking at it is it perhaps could be said, if serious harm has been caused, that it was likely to have been caused at the date of publication. At that moment, serious harm was likely to have been caused, thereby satisfying the second element of the section, and then subsequently it has been caused. But this would only ever arise if a claimant chose to issue proceedings more than a year after the date of publication, and the court had to try and state with some degree of certainty whether the serious harm, assuming it to have been caused, was caused within 1 year of the claim having been brought, in the context of there being a general discretion to do justice in any event. This is an issue which is more theoretical than real. It wasn't raised before the judge. It came out of the blue in the Court of Appeal. It was perhaps unfortunate that, having come out of the blue, the counsel for the defendants took a different viewpoint on the issue. But in my submission, the position is clear.
Mr. Price, can we get absolutely clear what your submission is about paragraph 67 of Lord Justice Davis's judgment? We needn't go to it. He says, as you recall, the moment of publication is ordinarily the moment harm will have been caused. Do you agree with that or disagree with it?
No, I disagree with it.
You disagree with it?
The moment of what Lord Justice Davis is referring back to what Mr. Justice Bean said in Cook, where he said it can't be the moment of publication because the harm isn't caused then. The moment of publication is when the presses roll and when the article goes online. And in any event, if you were to judge that as the moment for has caused or is likely to cause, the two would both be compressed. If you were to ask at the moment of publication, has serious harm been caused or is it likely to be caused, there'd be no has caused there.
But you've conceded there might be a likelihood.
There might be a likelihood, yes.
There might be a likelihood.
Might well be a likelihood,
Yeah.
yes. And likelihood in this case is up for grabs because there's been no finding by the judge on likelihood. But taxonomy is extremely important. One has to be clear on the taxonomy between has caused and is likely to cause and state which one of these alternatives the case falls into.
Yes?
I think I've said everything I need to say in relation to the construction of Section 1. Moving on to what in my submission is the real issue here, which is how do you prove serious harm has been caused? The role of inference. I stated at the outset of my submissions that the appellants contend for an obviousness test. Are the circumstances, that's all the circumstances, such that the publication of the statement is so obviously likely to cause serious harm to a person's reputation that it is unnecessary to adduce such evidence? Totally accept that facts can be proved by inference, but the circumstances in which it's permissible to draw an inference depend on the nature of the fact that requires proof. Lord Justice Davis referred to a criminal jury drawing an inference of fact on the basis of circumstantial evidence. Well, it may well do so, but that's a different fact that has to be established. The fact that has to be established in relation to Section 1 is that the claimant's reputation has been seriously harmed by the publication of the statement complained of. And I ask the following: if the claimant has not adduced any evidence of harm, or even any reaction whatsoever to the publication, and it's not obvious that serious harm will be caused, what is the principal basis for drawing the inference that serious harm to reputation has been caused? Well, the answer to that is said to be, it's difficult to obtain evidence of harm to reputation. Well, in my submission, that's wrong. I'll come on to why it's wrong. But at best, this could be seen as an argument against having a requirement to prove serious harm. Because there's a dual inferential burden on the claimant with a serious harm test, not only to infer that harm has been caused, but the court can be satisfied that it's sufficiently serious, characterised as serious. The answer to this coming from is, oh, well, it's all very difficult to prove. I think we need to, in my submission, analyse this a little bit closer.
Of course, Lord Justice Davis did infer serious harm having been caused. You say the test is only when it's obvious. I think if you read paragraph 86, he didn't use the word obvious, but I think he might well have used the word obvious.
He did use the word
He said it was plain.
He did.
So I wonder, is there much real difference between you and the judge on this?
Yes, because his finding of obviousness is really no different from just the meanings that were conveyed by the statement and the extent of publication. A combination of factors, which were three factors essentially: the meaning conveyed, which he just took from the repetition rule, that the claimant has committed these various criminal offences, the connections of the claimant to the jurisdiction as found by the judge, and the extent of the publication from the defendant's newspapers, the size of circulation. Those are the three circumstances that he took into account. The judge didn't make a finding of obviousness. The judge questioned whether a finding of obviousness was necessary. But I can deal with Lord Justice Davis's finding of obviousness. I do have to deal with it. But at present, I'm trying to contend for the principle that there should be an obviousness test, and that the approach to Section 1 would be fairly straightforward. You would start off by saying, looking at all the circumstances, and that would be essentially how the claim is pleaded in the particulars of claim, is it obvious that serious harm is going to be caused or has been caused in these circumstances? And if it's not, then the claimant has to do it a little bit harder. The claimant has to come up with some evidence of reputational harm on which the inference can be based in combination with the evidence.
Well, as my Lord points out, Lord Justice Davis said, it is plain that an inference of serious reputational harm arises. What's the difference?
No, I accept that Lord Justice Davis held that it was, I think he actually uses the word obvious. I accept that Lord Justice Davis held that this was an obvious case. In my submission, he was wrong to do so and wrong as a matter of law to do so.
Well, perhaps you can explain to us why.
As I say, he took into account three elements. The first was the meaning conveyed by the words.
Yes.
And that's where the repetition rule becomes relevant. The judgment cites the article in the Huffington Post, which clearly stated that the claimant was guilty, he was an appalling person, and it's a complete travesty what's happening to his former wife. The articles that my clients published were reports of her allegation, from which it was evident that they were denied by the claimant. They'd not been found to be true, been tested in a court. One of the Evening Standard article specifically said they hadn't been tested in a court. And that has to involve something on the weighing on the side of the defendant. That has to be a factor against inferring serious harm. I'm not saying that a reported allegation has no capacity to do harm, but it's not as serious as an allegation that has been found to be true. The repetition rule does not allow discrimination between a reported allegation and an allegation found to be true.
Or an allegation asserted to be true.
Yes.
Yes.
So I submit that Lord Justice Davis should have discounted or taken into account the fact that these allegations were reported. And one of the grounds of appeal to the Court of Appeal was that the judge did not do this. He referred to the readers trusting the publishers over the claimant in relation to these allegations. But it wasn't a battle between my clients and the claimant. It was a battle between Afsana and the claimant because it was Afsana's allegations. This point really wasn't addressed in the Court of Appeal's judgment. And I do submit that untested claims made in the context of an acrimonious divorce attributed to the family of the wife are A, irrelevant to the respondent's competence in his chosen field, and do not detract from his apparent status as a prime candidate in the aviation, aerospace and automotive industry within the UK. Similarly, in a personal context, people tend to make judgments on others on the basis of what they know of them, not how they are portrayed by the families of former spouses in short-lived, unsuitable marriages. The articles aren't directed at the respondent. They don't demand a judgment be formed on him, as opposed to the legal system in the UAE. It's the reality of it when you read the articles. You have a list of meanings that arise by operation of the repetition rule, but then when you look at the articles, no one's going to come away thinking that those meanings are definitely true. So it should surely be open to a defendant on a Section 1 determination to say that this is less serious because it's reported. And the Lord Justice Davis doesn't really grapple with the concept of serious harm.
Well, now, is this still the first element of the three? Or?
The first element of the three is the repetition rule. So
Yes.
he took into account the allegations in isolation.
Yes.
Then he took into account the extent of publication. But the reality of it, in my submission, is that even on the basis of the connection to the jurisdiction that were found by the judge, only a very limited number of readers are going to understand this article to refer to the claimant. That's another factor to bear in mind, in opposition to any suggestion that this is an obvious case. No discount given also for the fact that the Evening Standard article comes some time after the other publications, and the likelihood being that people who, insofar as people are going to see the media coverage, understand it to refer to the claimant, that's already happened before the Evening Standard article is published. And the third point he relied on was the connections with the jurisdiction, which in my submission are limited. But there's a more fundamental issue, which is grappling with the nature of what is meant by serious harm. The judge draws a distinction between the harm and the consequences, which I accept as a matter of principle, but he didn't grapple, in my respectful submission, with the submission that was made to him on behalf of the appellants, which is, if in a determination a year and a half after the publication complained of, there's not only no evidence of any adverse consequence, there's no evidence of any reaction whatsoever, or no evidence of anyone even reading the articles. On what basis can you infer that any harm that has been caused can be categorised as serious? And with respect, Lord Justice Davis doesn't really grapple with that. He just says, oh, well, it can happen later.
And surely it's open to him to infer that the articles would have been read I mean, the circulation figures that are given hardly admit of any conclusion other than that the articles will have been read.
Oh, the articles would have been read, but the crucial question in terms of reputational effect in reality is how many readers would have understood it to refer to the claimant. And bearing in mind that Parliament has effectively required a serious and said that substantial harm is not enough. At what point does one say, okay, you had substantial harm, but it's not serious harm? It must be in terms of the consequences of the publication. The judge played a numbers game, went through and estimated how many readers may have read the articles and understood them to refer to the claimant and thought the worst of him. But I mean, essentially, that's guesswork. And then the question arises, at what point does any harm to reputation become serious? Because if that's not properly determined, then it will be very easy simply to infer serious harm from the publication of an imputation which crosses the Thornton threshold and has been published to a more than nominal number of people. That's clearly not what Parliament intended by imposing a serious harm test. Almost any defamation action can pass that hurdle. At one point the judge referred to 12 people knowing the claimant and thinking the worst of him. It's a very low hurdle. And in Lord Justice Davis' approach, when he contemplated, in my submission with respect wrongly, the possibility of a further hearing on serious harm, if the meaning was sufficiently serious, he said at that point it could be open for the defendant to call evidence to show that nobody believed the allegation. Well, that's an incredibly high burden to put on a defendant, and not really how Section 1 was intended to work, that it's open to the defendant to have to prove that nobody believed the allegation. I ask, what is the difference between substantial harm to reputation and serious harm to reputation? In my submission, the only satisfactory answer is that serious harm to reputation has some form of adverse consequence that has been caused or is likely to be caused of a sufficiently material kind. And there's absolutely no evidence of that this claimant has brought. Of course, if someone is a UK citizen and has an established reputation in this country, lives and works in this country, his family is in this country, his friends are in this country, and a serious allegation is published in a national newspaper in this country, of course there's likely to be evidence of a reaction. The absence of a reaction simply reflects the limited connections that the claimant has in the jurisdiction, but the way of looking at it should not be to try and work out the extent of the connections and then guess at number of readers. It should be the correct approach should be looking for evidence of harm, and neither the judge nor the Court of Appeal approached it in this way. They weren't looking for evidence of harm. And in my submission, they should have been in this case. This was a case where it was not enough for the claimant just to turn up and say serious allegations have been published against me in a national newspaper. That perhaps brings me back to the point I was making about the assumptions that are being made about human behaviour and the related issue of the availability of evidence of harm in the modern era. It said there's no evidence of harm because such evidence is very difficult to obtain. So therefore you can safely infer that serious harm has been caused by the publication of the allegation, even though there's no evidence of any reaction to it. In my submission, that assertion just can't be left untested because it has the potential to frustrate the purpose of Parliament in the 2013 Act. It's not helpful in my submission to compare how frequently evidence of harm was available prior to the Act, or perceived to be available prior to the Act, because claimants didn't need it. They could get substantial damages without any evidence of harm. There are a number of ways in which harm to reputation can be evidenced in the modern era, and they do not necessarily involve overt shunning by people who know the claimant. I've set out a list in footnote 27, or page 12 of my case, paragraph 43, for bundle 74, electronic bundle 76. people inquiring about the allegations of the claimant directly or with a third party, failure to respond to communications from the claimant without any apparent reason, cancellation of a social or business event for no apparent reason, a general reduction in such activity, any adverse change in the claimant's social, commercial or professional life following publication which does not have an overt cause could be evidence of harm. And reactions to a media article can be evidenced by a wide range of social media. It may be helpful to look at a concrete example of a case where serious harm perhaps may be inferred, and where indeed there was also evidence of such harm. That is the Thedon case, which was a decision of His Honour Judge Maloney, sitting as a judge of the High Court. It can be found in Volume 1 of the Authorities Bundle, Part 2, Tab 31, page 645, and page 1147 of the Electronic Bundle. And this case was cited by Lord Justice Davis, paragraph 74 of his judgment. The claimant was a young man. He worked for a recruitment consultant. There was a falling out, and the defendant, his former employer, sent an email to 124 people working for 102 companies, all of whom were potential customers of the defendant company with whom the claimant had had some dealings. I'm taking this from the head note, I should say. Each of the emails alleged that the claimant had been dismissed for gross misconduct for passing confidential information to a competitor. All but 9 stated the defendants were considering taking criminal action against him. So there was a meaning determination, at the same time a hearing on Section 1. On meaning, paragraph 1, the judge emphasised that the reader is likely to read it with some care and to give weight to the details, take account that the misconduct had not been isolated but regular, and criminal action was being considered. The judge's conclusions on Section 1 can be found in paragraph 4 of the head note at the bottom of the page. Applying those principles to the facts of the case, the publication of the emails complained of had caused the claimant's reputation of a sufficient degree of seriousness to pass the threshold test set by Section 1. Claimant's complaint concerned defamatory words of a fairly high degree of gravity, published to a fairly substantial audience both in numerical terms and, more importantly, in terms of proximity and potential importance to the claimant's career. The claimant was brought by a vulnerable claimant, the former young man starting out in a competitive business and trying to make his way. Words complained of emanated from an influential and prima facie reliable author. And when it was held, those circumstances were sufficient for an inferential case to be raised. Then it's noted in subparagraph 6 that a number of recipients of the email had taken adverse action against him in consequence of it. Now, what is the difference between that case and the present case? In my submission, it is obvious in terms of circumstantial factors. It is who the claimant is, who the defendant is, who the publishees are, and their relationship to both the claimant and the defendant. The nature of the claimant's reputation and how vulnerable it potentially is at his stage, the reliability of the maker of the statement, in other words, the credibility of the allegation. That, in my submission, would be a case where you might say it's obvious for this claimant in this situation that this is going to cause serious harm to his reputation. And there was, in that case, evidence of a reaction. So one can quite easily contemplate circumstances, particularly where the recipients of the information are important to the claimant, that an obvious test will be satisfied. It's not enough.
Isn't this, I mean, it's going through, no doubt, a number of our minds. Where's the point of law of general public importance on this aspect of the case? Aren't you simply re-arguing the facts, having failed twice before?
Yeah, well, and there's, in my submission, the circumstances in which the court should draw the inference of serious harm and whether it should be subject to an obviousness test is a point of law. And it's of general public importance because, as I say, it's all very well to have the construction of Section 1 that requires a claimant to prove in fact that serious harm has been caused, as opposed to merely the tendency of the allegation. But if you too readily infer serious harm simply from the tendency of the allegation, then you get back to the position that you were in before. So in my submission, that is a question of law.
The most you can hope to get at it, surely, is a new trial.
Well,
It's rather difficult for us to make different findings.
well, in my submission, it is a matter that could be dealt with on paper. In fact, the whole thing should have been dealt with on paper because the other defendants could have followed the approach that my clients took, which was to accept that all the primary facts that were stated in the particulars of claim were true, but that wasn't sufficient for serious harm to reputation to be inferred. So if the other defendants had taken the same stance that my clients had taken, then there wouldn't have been any witness statements and there wouldn't have been any cross-examination at trial. I mean, it would have been...
Doesn't help us to make...
Well,
I mean, it may well be that things could have happened very differently.
yes, but I would ask the court to look at the allegations that are in the particulars of claim and ask whether those are sufficient to infer that serious harm has been caused to this claimant, bearing in mind that it's, in my submission, in the absence of any evidence, and there's no evidence there of anyone reading it or any consequence, whether this is a sufficiently obvious case for that inference to be drawn. But if the court, I can certainly understand that the court may not want to go down that route, and also there's a possibility of it's likely to be caused, which wasn't really explored because the judge made his findings on has caused. I mean, he simply said that if has caused hadn't been established, then he wouldn't have found it's likely to have caused to be established. But there was no analysis on that issue. And if the court feels that there were errors that were made in this case and there should be a retrial, then my clients wouldn't object to that.
Go further, wouldn't you? I mean, one might contemplate a retrial if one was satisfied that the judge had arrived at his finding.
Yes.
Basis of a mistaken view of the law.
Yes.
But much of your submission is effectively adopting Mr. Justice Warby's analysis of the law, but complaining that when he came to apply it to the facts, he did it in a manner adverse to your clients. But that was purely a matter for him, surely. If he got the test and law right, how are we in a position to deal with it?
He got the construction of Section 1 correct, but he was wrong not to subject this case to an obviousness test. In my submission, that's a question of law. Then he made 3 errors of law in his approach to the evidence. The first was the point on the repetition rule, and you can see in the core part of his reasoning where he talks about the harm that will be caused. He says that readers would not trust the claimant over the publishers. Now, this was said in the context of all of the publications when the Huffington Post did unambiguously assert that the claimant had been guilty of these things. My clients didn't do that. They reported them and they said that they were denied. And so that he should have taken that into account, firstly. That's the repetition rule point. Secondly, he placed significant weight on harm that would be caused by those readers who did not know the claimant, but got to know him in the future. And I think that was wrong in law. Those readers have to be put into the category of is likely to be caused. And it's an important point in my respectful submission because it's something that arises quite commonly in media publications in the modern era, where you have a hard copy publication, you have an online publication, and the online publication has a continuing life. So he was wrong on that, and I can deal with that now or subsequently. The third thing that he was wrong on was on the point in relation to Dingle, where he, certainly in relation to the Evening Standard, he gave no consideration to the fact that there had been very widespread publication of these allegations prior to that article being published. Those, in my respectful submission, were four errors of law that he made. The drawing of the inference without the obviousness test, the repetition rule, the categorization of readers who don't know the claimant but come into contact with him in the future, and Dingle. Right on any of those, then his conclusion is undermined and open to review, whether the review is here or first instance again.
Yes.
I think I've made my point on the repetition rule. Can I deal with readers who get to know the claimant after the Section 1 determination? I think I have to go to the judgment itself, which is Full Bundle, Volume 1, tab 5, and this passage is at page 90 of the hard copy bundle and page 280 of the electronic bundle. Perhaps I should just, before I go to those paragraphs, set out the structure of the judge's findings of fact. He starts at paragraph 132 on page 87 or page 277 with his findings in relation to the claimant's connections to and the extent of his reputation in England and Wales. That's set out in paragraph 132. He deals with some challenges that were made by the Huffington Post to the extent of those connections. And then he goes at 137 to deal with his core findings on serious harm, noting that it's impossible to determine with any kind of precision how many people actually did read the articles. I say he's wrong in principle to do that. He should be looking for evidence of harm rather than speculating as to number of readers. Paragraph 138 is where he refers to trust him over the publishers. That's the 6th line down, making the point that Mr. McFarlane, who was the one person who read any of the articles, who read the Huffington Post article, trusted the claimant, but he says others may not be confident enough to trust him over the publishers. That's not a relevant battle with my client's articles. And then he goes on to conclude at 140 to 142 that there is significance to people, the effect on his reputation of people who do not know him. And this passage, I submit, was an error of law. Starts at 140. What I think of rather greater significance is all this discussion tends to leave out of account, as if it was unimportant, the impact of publication on the claimant's reputation in the eyes of people who do not already know the claimant. A person can, after all, be defamed and seriously defamed in the eyes of those who do not know him. He does not need to establish an existing reputation in order to complain, and he may be entitled to substantial damage for the harm to his reputation caused by publication to people who have never heard of him. this was acknowledged in Jamil. The matter is discussed in Ames' case. If I can just pause there. The example that was given in Jamil, which was described as an extreme example, was of an unknown American who was about to visit an English town and was erroneously described in the town's local newspaper as a paedophile. The example that was given in Ames was a local English newspaper publishing an allegation of criminal activity about someone from Wales who was completely unknown in the area but was about to arrive to set up as a solicitor in the town. These extreme examples are clearly very different from the example in the present case, which is the ordinary run-of-the-mill media article in relation to somebody who's not very well known. In that situation, by the way, what's being contemplated here is someone reading the Independent newspaper online, doesn't know who the claimant is, and then possibly a number of years later coming into contact with him. And the harm that's been caused by his initial reading can be characterised as serious harm or contributing to serious harm. But the obvious point to be made is that a reader who does not know the respondent that comes into contact with him in the future is highly unlikely to remember these articles, or if he remembers them, he's highly unlikely to make the connection between the claimant and Afsana. What this is really relevant to is the possibility that this person would, at the time of his future contact with the respondent, seek to find out information about him, most commonly by carrying out an internet search. In such a case, any harm to his reputation arising from him becoming aware of Afsana's allegations would be future harm caused by, is likely to cause. It would be a reading of the article that occurs after the date of the Section 1 determination. That must be right as a matter of common sense. Why is this distinction important? Well, the assessment of future harm and any substantive defences available to it, if it's likely to be caused, must be judged by reference to the form of the article at the time it was read. Parliament intended to reward publishers who made amendments to online material following a complaint, specifically referred to in the Joint Committee report at paragraph 30, and that has happened in this case. The articles have been amended. Going back to the judgment, continuing at 141, it's quite clear that the judge approached this as a matter of principle. 141, he says, here it cannot be and is not said the allegations are trivial. The AOL readership was not enormous but not minimal, at least in the case of the first article. RPL may have published directly to as many as 1 million people and ASS to a million of 2.5. I take the defendant's case to be in summary, insofar as such publication caused harm to the claimant's reputation in the eyes of people whom the claimant does not know and do not know him, that is not serious harm. That is not an untenable argument in principle for the reasons given in Ames' case, but it would be a rare case in my judgment in which such a proposition can be made good on the facts. The actual principle is the other way around. It's only going to be an extreme example where the contact between the publishee and the claimant is going to happen very soon after publication, that a reputation will be seriously harmed, where the claimant is not very well known, and it's a transient media article that's not going to be remembered at the time of the future contact, which could be many years down the line. And the judge continues at 142, exploring the possibility of Louis going to school in England and the claimant working there, some unspecified time in the future. Third line of paragraph 142, he says, I do not think that if serious harm had not yet occurred, it could be said that future serious harm was probable for those reasons. What can properly be said is that present harm to reputation in the eyes of those who do not yet know a person can be serious if their opinion of him matters. What does that mean, if their opinion? I mean, obviously their opinion of him matters at the future point when he gets to meet them. It may be so if there's a real prospect that the claimant will come into contact with such people, or if he's likely to take steps to avoid such contact because of his tarnished reputation in their eyes. Just on that second option, there was no evidential basis for that. The claimant did not say, I'm not going to go to England because I'm worried about coverage. He just relied on these matters in terms of his connection with England, that he may come to live in England at some future point. And if one moves to 145, one can see that this is one of the two principal grounds on which the judge relies for inferring serious harm. This is in relation to the Huffington Post, I should say, but this reasoning is adopted for all the publications, albeit he finds that there would be more readers of my client's publications because they were national newspapers. But in terms of principle, 145A on the second line, he says that publication on the agreed scale is inherently likely to have reached a significant number of people, by which I mean at the very least a dozen, who know the claimant or know of him, whose opinion of him is likely to be seriously affected in an adverse way. Question what exactly seriously affected in an adverse way means. And B, that the probability of the claimant's reputation has been seriously harmed in the eyes of others whose opinion of him matters. So in other words, not of people who know or know of him, but who he may come into contact with in the future, picking up from those earlier paragraphs. And in my submission, that's wrong in law to put that into the has caused section, because the reality is these people will have not remember this passing reference to him, unnamed other than surname, in newspaper articles a number of years earlier. Has to be in the context of future harm. Which brings me to one of the criticisms that can be made of the common law's approach to determining meaning in a media case. It's the approach is based on the hypothetical reasonable reader who reads the article once, and then that meaning is set in stone. So if there's a million readers of a newspaper, then the claimant's been defamed a million times. But the reality is that a reader has no pre-existing knowledge of the claimant, will generally forget whatever he derives from the article shortly after reading it, unless it's of some particular significance. So you can start off with a million readers, but the real reality is how many actually know the claimant, and how important is the claimant's relationship to those people who read the article. And this is entirely guesswork in this case. Contrast, say, with the Seedon case, which I took the court to, where it's concrete. We don't even know how many people read this article, let alone how or why they're going to think the worst of the claimant, and let alone why that can be held to be serious as opposed to substantial. The next area of law relates to Dingle, the rule in Dingle. My submission is that there's nothing in Section 1 or any other part of the Act that provides for any restriction on matters that can be taken into account in relation to causation. So the issue is this a relevant circumstance? And is it disproportionate to take it into account? Those are the overriding considerations when taking into account whether a piece of evidence should be adduced. If harm to reputation is caused, particularly by a reported allegation, when a person finds out about it, if a person subsequently sees or hears a further report of that allegation in terms which are not materially different, no significant further harm is caused. That must be right. It's a matter of common sense. And Nicola Davis made that observation when ordering the preliminary trial. if you're already aware of Afsana's allegation, does it make a difference that the Evening Standard has reported it again? If so, why? I can well appreciate the situation might be different if a newspaper reports that person A has made an accusation of domestic abuse, and then another newspaper reports that person B has made an accusation of domestic abuse. But in this situation, it's just the same reported allegation. So if you're already aware of it, what is the basis for saying that if you read it again, it's going to cause serious harm to the claimant's reputation? The judge recognised that Dingle, which is the exclusionary rule in relation to mitigation of damages, preventing just this sort of analysis, has been criticised for departing from common sense. Well, we don't have to worry about the merits of Dingle in my submission, because that case is solely concerned with mitigation of damages. Mr. Dingle did not have to establish serious harm to his reputation in order to be in a position to bring an action for defamation. The position is different now with the passage of Section 1. What the rule in Dingle says is that you cannot rely on previous publications in mitigation of damages to say that the claimant's reputation has been harmed by the previous publications. Why should you transplant this rule to Section 1? And where would it stop? Would it be the case if there were 100 media reports and then one person came along and commented on the allegation that was already widely known, that we'd have to ignore all the previous coverage in determining whether the subsequent article which commented on things that were commonly known, to ignore all that in determining whether that publication caused serious harm to reputation? That would be absurd and, in my submission, unfair. And this new section has to grapple with the reality in which news is covered in the modern era, which is that allegations do get widely reported in different ways over time. And it would be, in my respectful submission, artificial and illogical to ignore what's come before in determining the harm that's happening from what's published subsequently.
Yes.
I mean, I accept that the principle in Dingle has some application, no doubt, in terms of that if you have, say, a number of articles on the same day and there's proof that serious harm has been caused to the claimant's reputation, but it might be difficult to show which publication has caused it. And the ordinary rules of causation in relation to material contribution to an injury could perhaps apply. So that Section 1, when it refers to the publication of the statement having caused serious harm to reputation of the claimant, that could be a material cause, where it's hard to distinguish between a number of publications. But a blanket rule, in the same way the blanket rule on the repetition rule, is not consistent with either the wording of Section 1 or Parliament's intention in relation to this provision. And this case, the present case, is not a case of the type that I've just given to the court, because, firstly, there's no evidence that the composite media publication has caused serious harm to the claimant's reputation. And it's just a question of trying to work out who's caused it. Secondly, there was a lengthy gap between the initial publications round about the 20th of January and the Evening Standard article of the 11th of February. And as an evening paper, there'll be a much larger overlap of readers with other publications that had already run Afsana's allegations. The judge simply relied on the estimated total number of readers of the newspaper as a whole. I submit the likelihood is that if there were any readers of the article who knew the respondent, it's highly likely that they would also have been aware of Afsana's allegations by then. It's important to bear in mind that the context here is the claimant is not coming to court and saying, here is a concrete consequence of the Standard's article, which has caused serious harm to my reputation. The claimant is relying solely on inference, on the basis of numbers and allegations. So why shouldn't it be open to the defendant to come to say, well, hang on a minute, by that stage, if you're looking at what's likely is that people, if there are any people who know you, who've read these allegations, they would have known it beforehand, the way the grapevine operates now. So that leads me to the conclusion set out in paragraph 69 of the case on page 81 of the core bundle, page 83 of the electronic bundle. Court of Appeal erred in its construction of section 1. The judge erred in finding that the respondent satisfied that section 1 hurdled by inference in the absence of any evidence of harm. Even assuming that all the primary facts relied on by the respondent are true, they are insufficient to draw the inference of serious harm to reputation from the publication of any of the articles. The reason for that is, as I say, it's not an obvious case. The judge did not apply an obvious standard. Next, the judge erred in taking into account in determining has called that there will be people who read the articles and did not know the respondent and may get to know him at some unspecified point in the future. 69.4, the judge erred in simply relying on the meanings arrived at by operation of the repetition rule and failing to take into account the articles merely reporting the allegations attributed to Afsana and her family. 69.5, the judge erred in failing to take into account by virtue of the rule in England Afsana's allegations are reported in many media and other publications, a number of which have a greater print and or online readership and or prominence in the appellant's newspapers and or name the respondent and or were published prior to the appellant's articles. And then I make reference to the appendix. I mean, that really goes into considerable details, the judge's findings of fact, but if the court's not with me on any of those other earlier points, it's probably not necessary to consider them. And my primary submission is not necessary to consider them because they're small points and one has to focus on the bigger picture point, which is that this is not an obvious case and there's no evidence being adduced by the claimant. So that's the end of the inquiry. He fails. And then the Court of Appeal erred in upholding the judge's approach to the matters referred to above. All of those points, in my respectful submission, involve points of principle and questions of law.
Yes.
I haven't dealt with is likely to, but in my submission, if that's a live issue, it should go back for a determination at first instance. I've suggested that this court may want to deal with it. I'm happy to make submissions on that. Those submissions would have to involve, I suppose, considering the available material that's online at the moment. Most of the stuff that's online at the moment, if you do a search against the claimant's name, is this court case. Nobody could do a search of this claimant without realising that he's hotly denied these allegations. Thus far, Muslim J has found them to be substantially untrue. There is a Court of Appeals reserved judgment on an appeal by Afsana, including in relation to his findings of fact. But it's inconceivable in my submission that the continuing publication of these allegations by the appellants in their articles online could possibly be likely to cause serious harm to the claimant's reputation, given what's out there already, and on the basis that it hasn't caused serious harm to his reputation thus far. We only need to look at it as likely to if the claimant hadn't established that it had been caused. Judge found against him on his likely to. I don't really know what more I can add in relation to that issue, should it fall for determination.
Thank you very much.
Unless I can be of any further assistance, those are the submissions on behalf of the applicants.
Thank you very much indeed. Mr. Price. Ms. Page.
So Mr. Price has been very economic. He's an hour and a half short of what he was expected to do. And this is a case that we suggested should be listed for 1 day, and it's been listed for 1.5 days.
Your prediction may prove to be correct.
Well, it may well prove to be correct, yes. I was expecting to have an hour this afternoon and then more time to drill down on things tomorrow. That said, I will try to be as economic as I can, but there's an awful lot about defamation law that one needs to know and needs to understand. One needs to understand what actionability is, why actionability and the presumption of damage are important, why they unlock the remedies that people need in order that articles like this one that are still up are not still up, that you can get vindication, that you can get damages for injury to feelings not parasitic upon showing actual damage. One of the major harms caused by defamation, the publication of defamatory falsehoods, is the extreme distress that it can cause people. That is compensatable at common law. We don't know from Mr. Price's submissions what the implications are of his analysis. If he is right that you have to show, in all but an exceptional case, you have to show an actual adverse piece of harm, and he's talking about consequences, not the actual reading of it, but proof of it in the form of something happening, and he gives some examples in footnote 27, all of which one would think would be attacked on causation grounds and as on remoteness grounds if we did get into the world he wants us to get into. But we don't know whether, this has never been made clear, whether if you have to demonstrate a piece of harm because harm is a requirement of the cause of action, are your damages limited to that harm? If all that you can show is a brick through the window, and assuming there wasn't an argument about causation or remoteness there, is your damage limited to the harm done to your reputation by the person who threw the brick through the window? Or are you entitled to vindication? How do you get vindication? Vindication is quite unrelated to the extent of publication or the mode of publication. Vindication damages and a right to have a verdict on liability, vindication damages, are what enable you, as the authorities that we've cited, to point to a figure of damages whenever the libel may emerge in the future and say this demonstrates the baselessness of the allegation that was made, however long ago it might be. At the heart of this case, as in most cases of defamation, is the striking of the appropriate balance between protection of reputation and freedom of expression. And at the center of the work that the common law, through the work of the judges over the centuries, has achieved, is a balancing and a constant rebalancing from the era of the meteori sensu rule, when trivial actions were discouraged by reading down the words to find the least offensive allegation, to then developing the test of the ordinary reasonable reader. And the test of the ordinary reasonable reader is what is now established law as to the way in which the court effectively predicts what the consequences will be or what the consequences have been if particular words are published. And there was a point, certainly in the Court of Appeal argument, where it seemed as though Mr. Price was saying that the only thing that matters is whether harm has been caused. So in other words, the examination, the court would not have to go through the examination of saying, what do the words mean? Applying the ordinary reasonable reader, in those meanings are the words defamatory? In other words, would they substantially affect in an adverse manner people's attitudes towards the person? That you would actually go straight to, well, where's the evidence of the harm? But he's not. He's actually made it perfectly clear today. He's saying that what Parliament has produced is a double hurdle. So you go through the exercise that the common law has developed in order to decide whether you can predict that there will be adverse consequences. And he says, but that is not a reliable means of doing it. So if there are no adverse consequences, it doesn't matter how the common law predicts what the consequences would be. If there are adverse consequences, then presumably that would demonstrate serious harm, even though the courts might have thought that it wouldn't meet the serious harm threshold, applying the objective tests. Now, there have been a few interventions of great moment by Parliament, and even the 2013 Act, while seemingly radical, is not radical in terms of the balance as it is set in the common law between these two interests. Leaving aside interpretation of Section 1, the law, as it has been developed, certainly in the past 20 years since the Human Rights Act, since even the eve of the Human Rights Act, has been pretty much lifted into the Act. I'm leaving aside Section 1, and I'm going to show you other aspects of the Act in a moment. So, over the past 20 years, the force of the Human Rights Act and the importance of Article 10 have been the subject of constant cross-checking by the judges as they have shaped the law, shaped the defences. The Reynolds defence is a total creation by the judges of a public interest defence, which balances protection of reputation against freedom of expression. And that defence, and it's quite express in Lord Nichols, is in the context of a defamation law which treats the cause of action as accruing upon publication and completes the cause of action by the presumption of damage. So the Reynolds defence, which has been lifted almost, well, completely unchanged, or entirely unchanged, has been lifted into the Act in Section 4, that being a defence which evidently Parliament thought was a good development, but one which is presupposing actionability per se for libel. The defences of justification, as it used to be known, is now a defence of truth. That has also been developed in the context of a defamation regime of actionability per se and a presumption of damage. That too has been lifted in Section 2 into the Act, and the only abolition that there has been Section 5 of the Defamation Act 1952, because that has been reenacted, intending to be in the same terms in Section 2.3 of the Truth Defence. The defence of fair comment, as it was known at common law, was a very, very important defence for freedom of expression. That too was shaped, even quite recently in this court, in the case of Spiller. That too sets the balance between the two values in the context of defamation being actionable per se. So all of those defences Parliament has lifted into the Act, and we submit that it seems unlikely, or at any rate one should be very cautious, to impute to Parliament that its intention was to preserve the balance set by the courts in the common law defences in their existing form and put them into the Act, but radically, and it would be radical if Mr. Price's arguments are right, radically alter the other side of the balance and remove actionability per se. That would be a huge tipping of the balance. And it would, in fact, mean erecting a new and near impossible barrier to actionability. What at bottom Mr. Price's argument boiled down to the end of his submissions really was this. Through the interpretation he wants of Section 1.1, he wants, and to use his expression, to use in another context, blanket rule. He effectively wants a blanket rule whereby a court, as a matter of law, could never treat the absence of serious adverse consequences as compatible with the Section 1 test having been met. He referred to this as being the actionability per se. He opened, as he does early in his case, with some remarks of Lady Hale. And I think perhaps it would be helpful to see her remarks, because she said a little bit more than actually is attributed to her about the surprising nature of defamation. Her remarks that he has relied on come from the case of Jamil. It's Mohammed Jamil, so it's a different Jamil, and we have it in the authorities bundle at tab 23, which starts on the electronic bundle at page 921. But I wanted only to show the fuller context of Lady Hale's remarks. This was a case about whether or not, a very important case about whether or not actionability per se applied to companies, trading companies, and whether or not that was compatible with Article 10. And the answer is that it was held to be. Now, Lady Hale, in her general observation, is only interested with present purpose in her general observations, at page 409 of the report, page 971 of the electronic bundle, and 469 of the paper bundle, at the top, paragraph 152 is the quote, which is taken from Tony Weir in a casebook on tort, where she said it is that defamation is so tender to a person's reputation that it allows him to claim substantial damages without having to show that the statement was false, or that it did him any harm, or that the defendant was at fault in making it. In the case of an individual, all this is so well established, we've ceased to think it odd if we ever did, and it would certainly take the intervention of Parliament to change it. Now, over the page, at page 154, in the context of companies, she refers again to Professor Weir, in the middle of paragraph 154, referring to the earliest critical comment about bodies, trading bodies, or in this case, a district council being able to sue for defamation. And she quotes him saying, in the quote at C to D, there is still some justification, however, for the rule that the human plaintiff need not prove any harm. If the statement is defamatory, he will feel bad and others will think badly of him. The first need not be proved and the second cannot be. Indeed, this duality of harm can be presumed precisely because it is required. You get damages only if someone has been rude about you to someone else. Now, that's, I think, really all I wanted to refer to in that authority at this stage. Cases are replete all over the common law world, and even in the United States in the last Supreme Court case on First Amendment and defamation, that proving that you have suffered consequences, proving that you have suffered harm, is in practice very rare and extremely difficult to do. Now, Mr. Price took you to the case of freedom by a very experienced judge, Zola Judge.
Maloney QC.
It's tab 21, so it is, it's volume 1, part 2 of the authorities bundle, and, sorry, it's not tab 21, oh, 31, sorry, I've written down 31. Page 1147 is where it starts, but I just wanted to invite you to look at the bit of the head note where Mr. Price left off. He took you to the head note at the paper copy bundle, page 647, electronic 1149, at holding 6. But what Judge Maloney also said is what was missing in what Mr. Price referred to. The last sentence, furthermore, the fact that few publishees had manifested hostility directly to the claimant's face was not a reliable guide to his standing in the eyes of those who remain silent. I mean, that is one example of repeated statements by judges. It's the judgment of history that you do not know what damage you have suffered, and the lack of any adverse consequences is probative of absolutely nothing about the harm to your reputation. Mr. Justice Warby, in his judgment appealed from, we have that at tab 5 of volume 1 of the core bundle. He made the same statement on a number of points, one of them at electronic bundle, page 281, paper bundle, page 91.
Give me a volume and tab number.
It's core bundle,
Sorry,
tab
core
5.
bundle, tab 5, core bundle, volume 1.
Page 91.
Page 91, hard copy. He says, in relation to Huffington Post, but it's a universal applications. At the end of paragraph 145, the last two sentences, he said, for the reasons given above, I do not agree that the absence of visible or tangible evidence of adverse reactions from other identifiable publishees undermines my conclusions. As the claimant said in his oral evidence, though in different words, silence is not evidence of the absence of impact. And in fact, I see there's actually another passage, important passage, the same effect, paragraph 138 on the preceding page. He says, I do not think I would be justified in accepting the defendant's submission that the absence of tangible evidence of adverse responses to publication indicates that the true position lies towards the McFarlane end of the spectrum, in other words, the friend who knew it was not true. Mr. McFarlane is evidently a good friend of the claimant who is confident to trust him over the publishers on a matter of this kind. Only 2 other individuals have been named as having read some of the words, and there is no evidence for their reaction to whatever it was they read. And then he goes on to say, but it is only human nature for people with less close relationships whose opinion of a defamed individual has been affected to shy away from raising the matter with that individual. Sometimes there is an outward display of hostility or an overt shunning or avoidance of a person, but evidence of that kind has always been rare for obvious reasons. The advent of social media has notoriously increased public online denunciation by strangers, but there is no evidence that it is common for friends or acquaintances to do this. My conclusion, therefore, the balance of probabilities of tens of people and possibly more than 100 who knew of the claimant, read one or more of the articles, and who thought the worse of him as a result. He also says over the page about grapevine. Grapevine is a very important element that is taken in justifying damages at large, actionability per se, vindication damages. He says at B, at the top of the page, at the end of paragraph 139, I do not discount, however, repetition by email or word of mouth. I do not believe that the grapevine is nowadays wholly visible to the onlooker as the defendants submitted. And then he goes on to the importance of the impact on people who do not already know the claimant. And this is a claimant who works in an industry where the centre of recruitment, the recruitment hub, is in this country, and the people who provide the employment to people like him the world over are to a large extent based in this country and therefore potentially readers of these very serious, extremely serious allegations. And it is quite obvious from the way in which it's put by the judge at the end of paragraph 142, which is not in any way exceptional to a libel case. He says, starting halfway between G and H, more significant in my view is the nature of the claimant's work. He is in an industry that is by its nature international. He's remained in the Middle East for many years, but he travels a considerable amount. In his work to date, he's moved jobs internationally, shown an interest in working elsewhere. He deals with many people who are resident here. There is some truth in Mr. Barker's submission that the claimant's present centre of interest lies in the UAE. It does not by any means follow that he cannot be caused harm to reputation that is serious by publication in this jurisdiction. And that is why Mr. Lachaux, still on a mission for it against these defendants, needs vindication. This is why he should have a cause of action. He should not have to prove that the lack of adverse consequences for him is because no one believed it or because no one read it. The number of people, the readership, as we know, is massive of these newspapers. And if, as a condition of actionability, one has to prove that indeed you have had adverse consequences, then that is a total shift in favour of freedom of expression, whether rightly or wrongly, but heavily against protection of reputation. It would involve Parliament having decided that what the judges over the years and throughout the common law jurisdiction have thought was a near impossible task should be a task in order to unlock even a cause of action.
When you make that, say, prove. Are you using prove in the sense of producing evidence, documentary or oral evidence? Or are you using it more broadly as embracing inferences from undisputed or undisputable facts?
I'm actually using it in almost a third way. The presumption of damage, it's quite important to understand how these presumptions work, because the presumption of damage is treated by Lord Justice Davis as standing evidentially in the place of an inference, and he treats it as an inference that can be rebutted. If I may, I'd like to just outline how actionability.
Can you try and encapsulate what it is that you are talking about when you refer to the objections to the claimant having to prove something? Just so that I can follow where you're going.
Yes. Well, the claimant has a burden of proof of proving a publication, so a communication of words to a third party, that they refer to him and that they are defamatory of him, applying the test, we say, of Thornton plus, serious harm, tendency to cause serious harm to reputation.
I understand that. I think you may have misunderstood my question. I would like you just to tell me what you mean when you talk about proving something. Are you talking about the whole, I mean, your response to my question when I put it earlier, are you talking about drawing inferences, or are you talking about producing evidence, or are you talking about both? There's another possibility which isn't encompassed in my question. Can you tell me what that possibility is?
Yes, what that is that if you prove those three things, you win on liability and you are entitled to damages at large. You don't have to prove anything because you've proved it by proving the elements of the cause of action. You have to prove those, of course, to the civil standard of proof. So on the balance of probabilities, you don't have to prove any actual injury to reputation. You don't even have to invite an inference. You are entitled to damages for vindication. You are entitled to damages for your hurt feelings, whether or not you've suffered injury to reputation. The presumption of damage is a presumption of law. It is not a process of inference whereby the inference can be taken away by evidence from the defendant. It could have the effect. It doesn't mean to say that the detailed examination and inquiry, which Mr. Price would say should go into the cause of action stage, it doesn't mean to say that doesn't and cannot take place. It takes place at trial. But if you've proved your three things, you are entitled to a presumption of falsity, a presumption which means that the burden of proof is on the defendant, and Parliament has enshrined that in Section 2. You have a presumption of malice that is also enshrined because that is showing you have a qualified privilege or an absolute privilege. You're showing you have a justification, a lawful justification, and a presumption of damage which is not rebuttable.
That is what you're talking. You're talking actually about the presumption of damage at the moment. Now, clearly Section 1.1 was intended to ensure that some things which at common law would not have been treated as defamatory are not going to be any more because they're not serious enough. I mean, you've been describing the common law position, but actually the whole of this issue turns, doesn't it, on whether we accept that the intention of Parliament was simply to beef up the inherent propensity test as applied to the words and nothing else, or to deal with the impact. That in the end, one has to go back to the language because it's manifest that it was intended by this Act to change the common law in quite a few respects, and the question is whether this is one of them.
When the government put the bill out for consultation and it had the word substantial in it, they, as they said later when they changed it to serious, had intended to reflect the common law. Now, the common law, if you talk about a test of a substantial harm, you're talking about the Thornton common law test. After the Joint Committee said, no, we need a stiffer test, and they said it should be substantial and serious, the government said, all right, we're persuaded to raise the bar being the common law bar, we are persuaded to raise it, and they changed one word.
If they hadn't changed that word, Section 1.1 would have done no more than reproduce on your submission the common law. So your submission is that until they did that, there was no change whatever. It was simply repeating what would have been the position anyway.
Maybe we should have a look at we go to the first bundle of authorities and have a look at what the government said when they changed.
All of this is that there are indications both ways in the statutory notes and so on. We actually got to start, haven't we, before we go into any of this, with the language of the Act. Mr. Justice Warby thought that it was unambiguous and none of this helped. Isn't that the starting point?
Of course it is the starting point, but I think you were putting to me that the government intended that certain things that had been actionable at common law no longer should be. And
Draftsman intended that. I don't care what the government intended at the moment. If you satisfy the ambiguity test, one may have to look at that. We've actually got to concentrate, haven't we, on the language of this statute.
Absolutely, but can I just make, or at least provide the reference that when the government introduced the bill after it had considered the recommendations of the Joint Committee, it said, and it's volume 1 of the authorities, tab 10, electronic number 628, that the substantial harm test, this is paragraph 8, as they originally put the bill out for consultation, was to reflect the current law as articulated by the courts in a series of cases. Our view was that establishing a statutory test, and I was putting it into statute, would have the effect of strengthening it. And then they refer to the recommendation by the committee for a higher hurdle, and at the end of paragraph 9 they say, we are persuaded that it is appropriate to raise the bar for bringing a claim. We believe that a test of serious harm would do this while maintaining a balance that is not unduly restrictive on claimants. And if we go then to the Act, which we have at tab 1 of that bundle, if we go first to the explanatory notes, which are electronic number 523, paper number 21, the last sentence of paragraph 11 of the explanatory notes was then added. That was added at the same time that they decided to remove substantial and replace it with serious.
Sorry, could you give me that page number again?
Yes, electronic 523.
Thank you.
The section raises the bar for bringing a claim so that only cases involving serious harm to the claimant's reputation can be brought. And that bar was the common law bar. And that is what we have within the Act, and I see it is 1 o'clock.
It is. Well, it's 12:59. Actually, 1 o'clock now.
What?
No. We'll sit again at 2 o'clock.